Lohnas v. Luzi. Counsel.
Good morning.
Good morning.
Tamsin Hager for the defendants appellants, Dr. Luzi and Northtown's Orthopedics. Just as a brief point to begin with,
Counsel, may I interrupt you for a second?
Sure.
Would you like to reserve some rebuttal time?
I'll reserve 2 minutes.
Thank you.
Okay. As a brief point to begin with, the equitable estoppel doctrine is not before this court today. The defendant prevailed at the appellate division on the equitable estoppel doctrine. The appellate division unanimously determined that the equitable estoppel doctrine does not apply as a matter of law, and the plaintiff did not leave to appeal that holding. So any of plaintiff's arguments in the brief, with the facts and the arguments of equitable estoppel, and any arguments made here today are simply not properly before the court and have no place in argument today. Then turning to the proper subject of today's appeal, which is whether the continuous treatment doctrine applies as a matter of law, our position is that it does not apply as a matter of law.
In order for us to rule in your favor, do we have to make a broad rule that any gap in treatment exceeding the statute of limitations period is bars the application of the doctrine in all cases?
I think you could fall short of that, but I think the Curcio case is very instructive here. In Curcio, the second department, as was typical of the second department, held that a gap in treatment exceeding the statute of limitations was per se dispositive of a break in continuity of treatment.
But didn't we say something opposite that in Crawford, I believe the case is?
Oh, you know, I'm not familiar with that right at this moment.
Mazie versus Crawford.
Mazie
M-A-S-S-I-E versus Crawford.
Okay.
Yeah.
Well, when, it's just, if you don't mind if I go back to Curcio, when it did come before the Court of Appeals, the Court of Appeals did agree that there was no continuous treatment, there was no tribal issue of fact raised about continuous treatment, but it was on a different ground. It was because the plaintiff did not instigate a timely return visit to the physician, and it was enough, quote, enough for the Court of Appeals that during a gap that did exceed, that happened to exceed the length of the statute of limitations, a gap of 37 months, there was absolutely no contact whatsoever between the plaintiff and the defendant. I do think that's on point to what we're seeing here, where we have a gap that does happen to exceed the statute of limitations. It's 32 months. And during that time, there was absolutely no contact between the plaintiff
What
and the
you're arguing
defendant.
for, though, is a per se rule. That's the way I understand your argument. I understand your argument, you can correct me if you think I'm wrong. But I understand it to say that whenever the gap in treatment is more than the statute of limitations, plaintiff's out. That's it. And that's the way I read the second department rule, and that's not the way I read Curcio, and specifically not the way I read Massey versus Crawford, which says that the interval in visits is not a per se dispositive of defendant's claim the statute was run, but the burden shifts to the plaintiff, which means it's a question of fact.
Correct. And
That's the way I read it. Am I missing something?
I think to clarify, I realize the Court of Appeals is probably not inclined to make a per se rule that the statute of limitations.
Well, let me ask you this. Would you say that the second department rule is a per se rule?
I think the second department has shown in a string of cases that they have adopted that rule.
They seem to, I agree with you, it seems to be going that way, but the fourth department seems to be saying it's a question of fact in this circumstance, and you've got to look at each circumstance separately.
Well, I think each case presents its own unique facts.
So let's take it a step further then. So if it's a question of fact analysis, should we be dealing with this at all then? If it's not a per se rule, then, which is a legal question for the Court of Appeals, if it's just a question of fact analysis, should this court be addressing it, or is it really an appellate division question?
Well, I think that there are some questions of law involved here because of the fact that the plaintiff did not return, or sorry, excuse me, she was directed to return as needed. So that as needed does not rise to the level of explicit future treatment that's anticipated. It does not rise to the level of a future appointment at some future date.
But didn't he tell her this is going to be chronic, this is going to be with you, so you're going to have to come back as needed? It's not just, oh, come back if you have a problem. I mean, he specifically told her that this is, you're going to have this lifetime problem.
The fact that the problems were chronic or longstanding does not mean that there was always a course of treatment for those problems. And I would just point the court's attention to the case of the Pekarian case in the Second Department. In that case, there was treatment over a period of 17 years for a chronic and longstanding condition that was recurrent bladder tumors. And in that case, there were gaps in treatment that exceeded the length of the statute of limitations. We can just call them lengthy gaps. And because of those temporal gaps that were long, and that the plaintiff did not seek a course of treatment during those gaps, the court found that any continuity in treatment could be deemed to have
Well, isn't the
severed. question
of whether the plaintiff, whether there was an intent on the part of the plaintiff and the doctor that the plaintiff would return to this doctor?
Right. You have to have the intent on both sides. And when you have an instruction, when we go back to the office visit of September 5th, 2003, and that's a very isolated office visit. There was a 17th-month break before that. She returns only because she's been pushed up against a wall. We have a very discreet and complete visit there, and she's supposed to return as needed. She disappears from care and treatment for 32 months. During that time, with no contacts whatsoever between the plaintiff and the defendant, no office visits, no correspondence, nothing occurs between them. This is very distinguishable from the types of cases.
Look, isn't this a case where you have a patient, plaintiff here, who has a major severe shoulder condition, goes to defendant doctor to treat that, and that's what she's been going to visit this doctor for since day one. That's the first reason she went to him. His response to that is, we've got to do surgery, and the surgery, she argues, is handled in a negligent manner and results in all these other terrible consequences for her, she alleges. Isn't that sort of a question for the jury, and their factual question as to whether or not over the course of all that time, she's not just sporadically going to see this doctor, but she continues to see this doctor to treat the injury, the shoulder condition that's been, in her view, exacerbated by this surgery? That's the negligence?
I think that the case...
Well, let's finish off.
sorry.
And if that's so, again, why isn't that a triable, factual question for the jury that forecloses summary judgment?
I think that because the facts presented here, the undisputable facts, there's law out there that is in our favor, which I would point to the Olita case in the Third Department where...
What's the undisputed fact that you say does
She was to
not foreclose summary judgment here?
that she was to return as needed, and an as-needed instruction does not provide for continuous treatment.
Even when the doctor acknowledges that treatment is always needed? Because it's chronic, because she'll need another surgery?
He's acknowledged in a sort of an amorphous way that she may need a treatment, a surgery
Not so
down the
amorphous.
road.
Isn't this what he said to the insurance people? So
He said
there'd
she
be payment?
may possibly need surgery in the future, but it's at no particular date was determined. It was not even determined that he would be the doctor that would perform that surgery either.
Thank you, counsel.
Thank you.
Counsel?
May it please the court, I'm Brian Fitzgerald. I represent Darling and Lohnas. The defense argues essentially that you have to take the visit in September of '03 and look at it in a vacuum.
But aren't you essentially arguing that any time a patient sees a doctor for a particular condition, which is chronic, that unless and until that patient actually goes to a different doctor, it is presumed that there is continuous treatment, that the same doctor is continuously treating that patient, even though there may be, whether it's a gap in time of 20 months or 30 months or 50 months.
I don't think we really argue that in the context of this case. where she has had a surgery by the doctor, sees the doctor over a period of time 13 times, bringing us to April of '02, where at that visit, the doctor is describing the condition as chronic, where she continues to have the problems of the deteriorating glenoid, the deteriorating rotator cuff, the pressure on her acromion bone, all because the implant's put in at a wrong angle. It's riding high, it's oversized.
I understand that, but isn't the purpose of the continuous treatment doctrine to not force a patient who is in the midst of treatment to have to challenge her doctor until it's completed? But here, you know, she herself says, I didn't really think he was even going to help me, but I didn't know where else to go, basically. So I don't understand how based on the undisputed facts we have here, the policy implications of the continuous treatment doctrine are applicable in any way or are further.
Well, the basis for the doctrine we would submit is to look at whether on the date of the last treatment, whether there's evidence that both patient and doctor expected continuing treatment. In the context of...
But continuing treatment with this particular doctor.
There's no question. This Darlene Lohnas, over the course of 4 or 5 years leading up to '03, saw 6 or 7 or 8 doctors for various other problems and ailments. She even saw an orthopedist for a carpal tunnel surgery on her wrist. So she had even seen another orthopedist, but did not bring her shoulder problem to that orthopedist. As she clearly testified, or the evidence in the record clearly indicates, she put her trust and confidence in Dr. Luzi. Dr. Luzi was her problem, was her doctor for this problem, and that's who she had, and that's who she was going to rely on.
Listen,
And that's why she continued to go back to him.
Clarify for me what facts actually you say are in dispute. Summary judgment motion, we have to accept the plainest version of the facts. What facts are you saying that are in dispute that the appellate division is really relying on here?
That the visit of September 2003 was continuing treatment for the same condition or conditions. Mm-hmm. And what are the facts that it was, which at least raise issues of fact as to whether patient and doctor intended continued treatment. You can't look at September '03 in a vacuum. We go back and we look at April of '02, periodic symptoms due to her degenerated rotator cuff. Dr. Luzi describes the problem as longstanding and chronic, that she will most likely need further surgery, and that she would need a shoulder replacement. Now, in April of '02, after that visit...
Mr. Fitzgerald, hold on a second. The dissent, Judge Carney at the appellate division pointed out a couple of things, and I'd like you to address them. One was that he would dismiss because this was a patient-initiated appointment, and then he was told to come back only, quote, as needed, end quote, or PRN, I think they put it. Respond to that.
The dissent said 2 things, that, number one, she was only told to return as needed. No specific future appointment was made. Mm-hmm. But I don't believe that means he didn't expect to see her again. He said return as needed, and there's no question, given her history up until 2003, she was going to be back. And those same problems with the rotator cuff, the glenoid, the acromion, they were persisting. So she clearly believed she would be back.
If he had said, you know what, I don't know what to tell you, I can't do anything more for you.
I'm sorry, didn't catch the
When she
question.
goes back in September 2003, if the doctor had said, I don't know what to tell you, there's nothing more I can do for you, would that have broken the chain?
Well, in the Curcio case, which involves a nose surgery in 1974, and a subsequent follow-up visit where the doctor says you're discharged, and then there's a gap of, I think, 37 months, the court doesn't decide the case on the fact that the gap exceeded the statute. The Court of Appeals decided the case on the fact that there was a discharge from care. And your question raises, well, what if he discharged her? We agree. If he discharged her on September 3, 2003, that would have ended
So
the
if
care.
the doctor also intend, because it's both what the patient and the doctor intend, he needed to say, from your point of view, there's nothing more I can do for you.
Or
Don't come
as-
back as needed.
Yes, or as found in some cases, patient goes to a completely different doctor and ends the care herself. And after 2006, when she last saw Dr. Luzi, she went to another Dr. Patterson, and obviously, as of 2006, ended the care.
What about the requirement of a timely return visit? What does that mean? Here we have her saying, this has been bothering me the whole time.
The New York Court of Appeals has looked at cases which raise that issue. What is a timely return visit? They've never said it has to be within 2.5 years, the statute of limitations.
Well, I'm asking you, what is timely? Is it,
So in the context of this case, where she has these continuing problems, and 31 months goes by, okay, what's happening in that 31 months? Well, in May of '02, after the April visit, she's in so much pain, she needs a TENS unit. She testifies that after the 2003 visit, she is in constant pain, she's terrible, okay. But she's still young, and she may not be going back to Dr. Luzi sooner, because these shoulder replacements only last 10 or 15 years, and she's in her 40s. She's going to try to put off that shoulder surgery for some period of time.
And isn't
In
this
fact-
the whole point, that these are the kinds of matters that should be going to the jury, and that's why summary judgment's not appropriate?
Yes, and in the context of all of those facts, there are questions of fact then which we believe a jury should be able to decide in this case. I'd like to just comment on the equitable estoppel issue. I'm kind of in a catch-22 on that. We could have sought leave from the Fourth Department to appeal on the equitable estoppel issue, but we make a judgment call. We won in the Fourth Department on the continuous treatment issue, so let's not do that. We were concerned that if we did move for leave and it was granted on the equitable estoppel issue, then the continuous treatment issue would come up when we had won on that. So we're in a catch-22. What should we do? It's a little disappointing in that the Fourth Department, when they certified the question, they do it in a simple way: was the order properly made? Well, the order includes a ruling on the equitable estoppel issue. So now we say that issue is before the court too. And it's critical. This case is not like a lot of other cases that involve the continuous treatment. This case is a case where a subsequent treating surgeon found that the humeral head implant wasn't just a little off, a few degrees off. It should have been in at 30 degrees, and it was in at 80 to 110 degrees. That should have been seen by Dr. Luzi with his naked eye in the 1999 surgery that he did, and then when he opened up her shoulder again in 2002, he should have seen it. Now, he says, I didn't know. This is just as a self-serving statement by Dr. Luzi that he didn't know it was in wrong. Who's kidding who? And you get the equitable estoppel argument in these cases, not just by proving there's an outright lie, but also you can establish it by showing intentional concealment. Dr. Luzi, to determine the position of that humeral head implant over the years, could have done a CT scan, which shows the epicondyles of the elbow in a certain position. Then you can find out on CT scan whether the humeral head is in the correct position. He never orders one. That suggests to me that he doesn't want to order one because it will show he put it in wrong, very wrong. Dr. Patterson testified that when he saw it in the revision surgery in '06, it was 90 degrees at a 90-degree angle, but it could have been anywhere from 80 to 110 degrees. If it's 110 degrees, it's 80 degrees off. It should have been obvious. Dr. Patterson, when he first saw her, did an X-ray in retroversion. Malpositioning was suggested in the X-ray. First time he saw her, and we believe that there was intentional concealment of the wrongly positioned humeral head implant for years until she finally saw another doctor. And the equitable estoppel claim should be reinstated, and she should be allowed to proceed on her fraud cause as well.
Thank you, counsel.
Thank you.
Ms. Hager?
I would just reiterate again that the equitable estoppel doctrine is not properly before this court. It was not appealed by the plaintiff, and his comments are actually prejudicial and out of place today at our oral argument. And then going back to the continuous treatment doctrine, I think another case that's very instructive is the Devadis case in the First Department, which involved a 33-month gap in treatment, and the First Department held that there was a question of fact regarding the continuous treatment doctrine. Why it's instructive is in the distinct ways the facts are different from what we see here. In that case, the defendant ophthalmologist performed a LASIK surgery on the plaintiff, and he said to her, "I am your ophthalmologist for life. I guarantee the result of this surgery for life." In those circumstances, the court found a triable issue of fact regarding the continuous treatment doctrine. Here we
Does
do.
the doctor have to go that far to say, for life, I'm your doctor? Of course, that's obviously not true, because the patient could choose never to return to that doctor.
It was that the patient and the doctor, it was that going back to both reasonably intending the reliance on that doctor's care and treatment, concern and responsibility for overall progress. With that sort
What
of
I'm saying is the fact that this doctor didn't say that doesn't mean that other things that were said and done don't raise a triable question of fact for the jury to decide whether or not, nevertheless, that was his intention.
Right, but this doctor also said, come back as needed, and that's very distinct from the kind of cases where you have periodic and repeated visits, while a doctor may be attempting to treat the underlying symptoms and complaints relating to the underlying or the initial treatment. We don't have that here either. We don't have a situation where you're monitoring somebody at regular intervals to see if they develop cancer or to see if they have metastatic cancer developing. It's very distinct from the cases where the courts find a continuous treatment doctrine or a question of fact as to continuous treatment.
Thank you,
And-
counsel.
Okay, thank you.